Hi, my name is Gerardo Herrera, Communication Director of RiskMathics. We are here in the context of the Risk Management Training Conference, and we have two legends of the legal framework from financial markets that have participated in RiskMathics events for a decade already, I think, or more.
A long time.
A long time.
I was at the first one.
Ronal Filler and Gary Dewaal, friends, partners of RiskMathics. And today we're going to be talking about crypto and its regulation. When we thought that we had talked everything that we had to talk about regulation in financial markets, there comes crypto. I remember years ago when you used to talk about swaps,
Right.
or top-5. Remember when that was trendy? Well, now we're talking about crypto. Where are we stand? Is crypto a commodity? Is going to be treated like a commodity? Who's going to be regulating crypto in the US? CFTC, which one of the many regulators that you have? I don't even remember how many regulators you have. And based on that, what is it that we can discuss about crypto regulation in emerging markets like Mexico and Latin America? So probably I want to start with the transaction per se. The crypto transaction was basically unregulated, unprotected. And as far as I understand, it's going to have a legal framework that would allow for the protection of rights of the seller and the buyer. Is that right? Or am I?
Yep, no. So let me start and then Gary can expand. In my opinion, in the U.S., we have the most developed and mature set of laws and regulations in the financial services industry. I don't think any other country has the greater number of laws and regulations or the quantity and then how they are then carried out. But we also have a very backward approach. And in how we regulate financial products in the U.S., and crypto will come under this approach model, Congress in the U.S. first defines the product and assigns jurisdiction over that product to a regulatory agency. An example, in 1933, Congress defined the term security in our security laws. 1934, the Securities and Exchange Commission was formed, and the SEC has jurisdiction over any financial product that constitutes or falls within the definition of a security. 40 years later, Congress amends the Commodity Exchange Act, creates the Commodity Futures Trading Commission, or CFTC, and delegates jurisdiction of the commodity for future delivery to the CFTC. So here we are in the crypto land, and it's been around for several years now, but it's getting a lot more attention in the last 2 or 3 years. Is a crypto asset, a digital asset, a security? If so, the SEC has jurisdiction. If the crypto asset or digital asset is a commodity, the CFTC has jurisdiction. And unfortunately in the US, Congress has not acted or enacted any laws assigning jurisdiction over the various platforms and different types of crypto assets to any regulatory agency. And so what we've had done in the last 2, 3, 4 years, the SEC has taken a very aggressive approach. The CFTC has also taken a very aggressive enforcement approach. And what we have is called regulation by enforcement. No rules, no regulations, but the SEC and the CFTC have brought a number of enforcement actions against crypto firms, the principals, their founders, and have been successful in many court cases, not 100%, but that is the status of where we are today. Gary?
Yeah, so I might have a slightly different view. So I am convinced that at the time of creation, the securities laws and the commodities laws in the United States made sense. Back in the 1930s and even earlier for the futures laws back to the 1920s. And basically the laws made sense because it was a simpler time. There were no computers, commodities were ag products, securities were equities, they were bonds. And so a regulatory scheme based on those propositions is what was created, and it still exists today. The problem is that products have morphed. Futures, which were once based solely on agricultural products, now are based on financial instruments, even more so. Securities represent all sorts of different products, and there are different financial instruments, crypto being a good example. The problem is, by having a regulatory scheme that's product-specific, that every time there's a new product, like crypto, it's not there, or maybe it is there. In the United States, the problem isn't no regulation. The problem is inconsistent regulation among the states and among the federal regulatory agencies. What we really need is to have a regulatory scheme, and it's true for every country, that addresses fundamental principles of doing business in the financial space. Thou shalt not steal. Thou shalt not commit fraud. Thou shalt protect customer assets. Things that apply no matter what the asset is. And then, to the extent there are existing products and new products, you just plug them in. And anything that's unique to that product, you deal with that product. But this way, when a new product comes about, at least you have the core principles that are out there that apply to all financial products. That's what we need in the United States, and I actually believe it's a better approach globally. Stop regulating product. Accept the fact that there are common principles to all products and all new products. Let's institute those, and then let's build specific products, issues to the extent they're necessary. As far as where I think the world is right now, within the last couple of months, both IOSCO and the Financial Stability Board have proposed recommendations for global rules and regulations and laws dealing in the crypto space. And again, they're very effectively high principle, nothing objectionable, probably things that all countries should look at. But ultimately, again, I do think it still misses the mark. It's time to step back and realize that in the 1930s, we didn't have computers. In the 1930s, we didn't have many of the financial instruments that exist today. And by the way, in the year 2030 and 2040, we're going to have new financial instruments. We're going to have new technologies, and we're going to have new things that regulators are late to the game in dealing with, and therefore they're going to default to regulation by enforcement or no regulation, and potentially jeopardizing consumers and the public. So I think a different global approach and a different macro approach is overdue.
Okay. Well, that seems to be like a stalemate, isn't it? Now, I want to pick up on the security or commodity. Okay. Which is the discussion around what is your view of each one of you?
Well, in my personal view, it's different than the SEC's view. The SEC views has basically said all crypto assets other than Bitcoins is a security. I don't agree with that. I think you have to look at each individual crypto asset, how it's created, how it's traded, who trades it. You got to look at the total circumstances surrounding it before determining. I think the better legislative and regulatory approach is to give the regulation of crypto assets, at least in the U.S., to the CFTC. I think they're better equipped. Remember with Dodd-Frank, when we talked about it, CFTC was given 92% of the OTC derivative industry to regulate. The SEC got 8 or 9%. And I just think the CFTC personally is the better unit. But the CFTC only can regulate a commodity for future delivery. They cannot, even under current law, regulate what we call the cash or spot market commodity, unless there's some fraud in the sale of that cash commodity. So Congress has to really rethink where we go with the crypto asset space in assigning jurisdiction and under what format, what the level, and so forth. And I don't think we're there in 2023. I doubt if we're there in 2024 because of the presidential election. So we're probably talking 2025 before we see something more definitive.
Gary.
Well, this time I start off by agreeing with my esteemed colleague, Mr. Filler. I do believe that the SEC has taken a far too aggressive view as to what constitutes a security, and I do believe that there has to be rationalization. But this issue of disputes over what is a security and what is a commodity is nothing new. back in the 1970s, the SEC had a very, very aggressive view of futures on financial instruments, both in the situation of futures on Ginnie Maes, both in the situation of futures on index participation units. The SEC took a view that those were securities. The CFTC politely disagreed. At the time, in the absence of legislation, then Chairman John Shad of the SEC and Chairman Philip McBride Johnson of the CFTC sat down in a room and they said, here is a path that makes sense for everybody. Here is a path that cleanly divides up what is a futures under our regulation, the CFTC, what is a security under your regulation, the SEC. Ultimately, that evolved to what is both a future and a security, known as a security future, both under the SEC and the CFTC. The recommendations of the initial chairman and then later chair were incorporated into law, and we live happily ever after. Today, there are very clear numerical tests of when things are a future or a security future, and how things evolve. To me, the leaders of the SEC and the CFTC, because of what Ron pointed out, the political hemorrhaging that's occurring in Congress, they should sit down and see if they can devise a rational scheme that would work and make them both comfortable. If they can, and they propose that to Congress, I think there's a chance of faster movement. That being said, there are two good bills out there right now. One proposed by House Financial Services and House Agriculture, and one proposed by Senators Loomis from Wyoming and Gillibrand from New York, that are very thoughtful and comprehensive, and each would be a good starting point. So I'm optimistic something will happen, but again, probably not too quickly. Let the chairman sit down and see if we can figure out something quicker.
May I just expand a little bit on what Gary said? It's just not a U.S. Lack of harmonization issue, it's a global one. Today's world, it's a global financial world. I can sit in my home in Florida and trade markets all over the world. The laws and regulations globally are not harmonized. And I think whether it's IOSCO or some other organization, we do need to get together and figure out a way over the next 1, 2, 3 years of try to harmonize the laws and regulations in a common, to the extent you can. I know local jurisdiction, local laws, especially the bankruptcy laws in the different jurisdictions, will be hard to amend. But to me, a global harmonized approach will be the most effective for the financial service industry going forward.
Now, the fact of the matter is that whatever the U.S. goes, whatever way the U.S. goes, a lot of countries will go that way. Right? Countries like Mexico or Brazil.
Correct.
So that's why everybody's following up on the American efforts to put a legal framework on this quantum reality that is crypto. Every time you look at it, it's something different. And there are many different types, etc. So let's talk about regulators. In the U.S., you have one regulator too many, I think. Unless I offend you, I think it's, in terms of regulation, less is better than many. What do you think? Is this fact of the U.S. having so many regulators complicated giving a legal framework to crypto? Will it be easier for countries like Mexico, that we have 2 or 3 regulators and you get done with it?
So I've been teaching at different law schools for 45 years, a course on derivatives law. And in my very first class each year, each semester, I asked the following question: how many financial regulatory bodies, agencies, exist in the U.S.? Well, we don't have an audience to ask, and the answer is 175. Think about it. Every state regulates securities. Every state regulates banking. Every state regulates insurance, etc. Plus we have federal agencies. And over the years, and as Gary mentioned, we just have not harmonized or reformed that regulatory approach in the U.S. Be honest, in the crypto and the world of derivatives, we have 3 regulators, mainly 2, SEC and the CFTC. The Fed gets involved if there's any AML issues. But the SEC and the CFTC have not really sat down as they should have and harmonize this approach. There was 2 amazing reports issued in the spring of 2009 that followed the global financial crisis of '08, and both of those reports, written by some esteemed leaders in the financial community, both talk about how we need to reform our laws in the U.S. It got nowhere in Congress. So I don't see any reforms happening. So now the question is, and I happen to agree with Gary as well, any new regulations in the crypto space that you could then apply to Mexico, South America, Europe, anywhere, make it a more principle-based approach and figure out 5, 10, the 10 commandments of crypto regulations, and figure out what they are to protect everyone, and then let each individual country sort of define or explain how they interpret these 10 commandments. That would be my recommendation for a more harmonized approach. And if the U.S. interprets thou shalt not commit fraud one way and Mexico shall not commit fraud a different way, maybe there's room for future solutions or balance down the road.
Yeah, even as recently as the Trump administration, the Treasury Department under Secretary Treasurer Mnuchin issued a report that talked about the overlap in regulation. There's a great chart in that report that looks like a kid throwing a spaghetti against the wall with the different lines, and how it's overwhelming, but it just shows you how much overlap and redundancy there is in the United States. If someone from Mars was to land and look at the U.S. regulatory scheme, they probably would run away from our planet because it would just be so horrific. I will actually suggest that it is up to countries like Mexico and other countries around the world to perhaps be the leaders in a revised regulatory scheme that might make more sense, because I do think that it's easier for other countries. I mean, we have just on the federal level in the United States, various committees that oversee regulatory agencies. The CFTC is overseen by the House Agriculture Committee. The SEC is overseen by the Financial Services Committee. These guys do not want to give up jurisdiction over agencies, that give them some authority. So I don't see necessarily a rationalization occurring. It should occur. I don't think anyone disagrees. We've seen it in report after report after report after report. And that's even before we start dealing with the state issue. Moreover, part of the solution we have had in the United States is not to get rid of oversight, but to increase the oversight. So on top of the SEC and the CFTC is the President's Working Group, is the Federal Oversight, FSOC. I mean, it becomes crazy. But again, I think that other countries can maybe start thinking more rationally, like I've suggested, with core principles that apply to all financial instruments and even technology, and then deal with the specifics. I am very concerned that the same history that we're now seeing with crypto is going to be repeated with artificial intelligence. Right now, we all know that the developers in AI, users of AI, are fast and furious. People want to use AI. People want to develop AI. Recently, there was a meeting in Washington where some of the leading developers agreed to certain core principles of behavior. Applaud, because that's a good starting point. I think we need more of that in the absence of legislation. But again, to me, if there were just some core principles out there relating to financial instruments, financial technology, we'd be ahead of the game. We wouldn't have to, have nothing in place in an interim period like we are now in crypto while we're waiting for formal legislation.
Okay, I would like to wrap it up with a quick question, very concrete. When will we have a fully mature legal framework that sorts out most of the questions that we have been discussing? SEC, CFTC, commodity, security. When will we have it in the U.S.?
Gary? Sadly, it probably won't be until an episode like FTX that's far more serious and harmful.
This is what we need?
Correct. I would have thought FTX would have been the crisis. It hasn't. So clearly, regulators need something more serious. That was the issue, Doc.
I agree with Gary. I don't see it before 2025, but we do need a legislative fix before we can have the set of rules and regulations, because we don't know at this point which regulatory agency or more than one will be given jurisdiction over that particular product. So the Congress has to act first, and then once they assign jurisdiction over what we call a digital asset, then the respective underlying agencies, maybe more than one, will then hopefully harmonize their regulations. But that's another year or two. Think about Dodd-Frank. The law was passed in 2010. The first set of regulations came out in 2012. This is 2023, and they're not finalized yet. So it's not a quick fix, and it's not something in the near term. It's going to be a little bit longer term before we answer your question.
There was a famous American author, Upton Sinclair, who once wrote in a book that if you like sausage, you don't want to watch it being made. And I think that's exactly where we are in the crypto space. If you like effective legislation, close your eyes for the next couple of years.
So we're going to be still in no man's land in terms of regulation for the foreseeable future.
Well, we'll see it regulation by what the judges and the courts decide once these agencies bring these enforcement actions.
It's like a country with no constitution, and just judges deciding on each case.
Yep.
Something like that.
And every judge is different.
Yeah, it's messy. Okay, well, welcome to the crypto mess, like if we didn't have it already. Thank you very much, Gary Dewaal, Ronal Filler, for such a delicious conversation.
Our pleasure, and congratulations on a very successful conference.
Yep.
Thank you very
I
much.
want to echo that.
Thank you very much.